Hi, and welcome to Persona Interviews. I'm Rob Simmelcare. Last week, there was a landmark decision in the Connecticut Supreme Court allowing families of the victims of the Sandy Hook school massacre to bring a lawsuit against the manufacturer of the gun that was used in that crime. It was a case that made waves nationally, and the lead attorney for the Sandy Hook families was Josh Koskoff. He joins us here in his office in Bridgeport, Connecticut. Josh, congratulations on the ruling, and thank you for joining us.
Thank you. It's my pleasure, Rob.
So I want to take you back to the early part of this case. This is not what you do for a living, bringing lawsuits like this. There aren't many people who really do this kind of thing for a living. When were you first approached with this case?
Well, it actually started in a very organic and innocent way. I was simply getting a ride by somebody in the weeks after Sandy Hook shooting, and the person who was giving me the ride was a friend of the Soto family. And by the Soto family, I mean the family of Victoria Soto, who was the first grade classroom teacher who died defending her children on the day of the shooting. And at that point, what this guy said was, look, my friend, who's Vicky's father, could use some help with probate and things like that. He's just shattered, and they didn't know what to do. So I, of course, like everybody else in Connecticut, I would have done anything I could to help, given the magnitude of what had happened, and I was willing to offer my services just to help them get through what I call sort of the paperwork of death and other things that just happen in these terrible situations.
And where did it go from that early conversation to what ultimately became this claim? How did you ultimately get there?
Well, we got there through at least I and some of my colleagues here really wanted to do something to help because we are lawyers. We figured, why don't we see if there are actions that could be available to these aggrieved families? And it took us almost exactly 2 years to get to the right claims, but we went through a lot of different investigations. We brainstormed. I was shocked at the difficulty of the legal hurdles that we were facing, because as you pointed out in your introduction, I'd never handled a gun case. You couldn't be a law firm and have a business or a corporate law firm or any kind of law firm that specializes in gun cases, because there aren't that many.
Right, and there aren't that many because the legal hurdles that have been constructed legislatively to protect the gun industry are so great.
Exactly.
It's quite hard to find a way around those, and that really, at the end of the day, is the thrust of the victory that you guys had last week.
Yeah, exactly. Now, I never knew about this immunity by the gun companies because, like everybody else, I just was ignorant about it. I don't even know that much about guns. At least didn't know much about guns before this case. And so when I saw this immunity, this law, I was really shocked that it could be constitutional, yet it had withstood constitutional tests.
This is the federal law.
The federal law. They call it the Protection of Lawful Commerce and Arms Act, or it's known to our office as PLACA. And like plaque, it kind of sticks in the legal teeth, and it was shocking to me. And yet every case I looked into was felled by this law. And I've described the law as kind of like the Mount Everest of hurdles. And just like, staring up at Mount Everest, when I saw this, I thought, how are we going to get over this?
And the law essentially says that you can't bring a lawsuit against the manufacturer of guns for crimes that are committed with those guns.
Exactly.
So the whole process that people have seen take place with the tobacco industry, where ultimately products liability claims against tobacco manufacturers brought about massive verdicts. Essentially, the law was meant to protect the gun industry from that exact same sort of liability.
It certainly has that effect, and was enacted to prevent that kind of discovery that could expose, industry wrongdoing. And in particular, the gun industry was worried about cases that were brought by municipalities like New York City, because what they realized is, look, if we have to clean up for all the damages and mess that are caused by our products, we're going to go out of business. And it's been largely successful. I mean, it's been almost impenetrable. There's been a couple cases, but I think that but there are some exceptions, Rob, but some of the exceptions are kind of exceptions in name only. Right. And we managed to find the exception that applies here, and thankfully the court agreed with our position.
So how did you arrive at the theory that you ultimately brought? And you brought a number of claims. It
Right.
wasn't just the one that you won on. There were a number of others that you brought that you
But we
lost on.
Yeah, right.
And that's the way it is in law sometimes. How did you guys come up with this theory of the marketing materials and the trade practices essentially being the thing that you felt could lead to a successful claim?
Right. Well, what I'd say is that partially the theory found us, and partially we found the theory. And the way I say the theory found us, the day after the shooting, one of my clients, Jackie Barden, was looking online because you have to go back to 2012. People didn't really, unless you owned an assault rifle, you didn't really know much about them. The public didn't know what an AR-15 was. Again, there was a subset of people who did, and we didn't know about the marketing of it unless you were into that kind of thing. Anyway, Jackie Barden was on her computer and saw the man card advertisement from Bushmaster, which essentially says your man card has been reissued with a picture of a Bushmaster, and was horrified. And we were all, and I the kind of marketing that Bushmaster / Remington did on this rifle came to that same reaction, especially in the wake of the shooting, which is how can this is the most unethical, most immoral, most reckless type of corporate marketing you could imagine. Pictures of a lone gunman. So in that way, it found us, because that's just wrong. But just because something's wrong doesn't mean that you can do anything about it.
Right.
And it just so happens that, so we put that together with the state statute that basically would address that kind of wrongdoing, called the Connecticut Unfair Trade Practices Act, which is a remedial statute which protects the citizens of Connecticut from this kind of thing, or should. And as it turns out, one of the exceptions to PLACA is that if the company does something that violates a state statute that is applicable to the sale or marketing of firearms, you can bring a claim. And so we put those two things together and ended up where we are.
One of the challenges that I know you faced is this was a novel use of the state law.
Sure.
As well. And typically unfair trade practice type claims are for commercial relationships.
Right.
Someone's selling something that they know is bad, and they sell it to a lot of people, and those people are damaged by it, and they
Right.
bring a claim for that. And that was one of the hurdles that you guys faced, and that I believe you actually lost on at the trial level, if I'm not mistaken.
Exactly.
That there wasn't really a commercial relationship between these families,
Right.
whose children or relatives were killed in this massacre, and the manufacturer of the guns. How did you overcome that?
Well, we overcame it by, it's an excellent question, and you obviously did your homework. But basically, we overcame it by, there were a number of reasons how we were able to overcome it. First, it had never been fully resolved in Connecticut as to whether you needed a business or commercial relationship. So I think what you're saying is that usually, to bring a claim like this, you would have to go and buy some type of product and find out that it was the result of some fraud or some misrepresentation, and you get your money back or some damages. And if that's times 1 million people, that can be a big deal. Right. But we did it by first going to the language of the statute. There's a principle in law that when you're dealing with a statute, is the first thing you look at is the plain meaning of the statute. If that's clear and unambiguous, you're good. Or you're not good, you just have to apply it.
Right.
So we noticed that the statute didn't have the requirement of a business or commercial relationship. There had been some previous iterations of the statute that implied that, and there had been some case law, but the statute itself does not have that. So that's number one. And number two, we had to establish that while it is true that most of the time you're going to be aggrieved by some violation of CUTPA in a commercial situation, that some people that they're like this situation, you can't be more aggrieved than the families are here. You can't have lost more or suffered more. And they are the direct, they are the people first in line that are going to be harmed by this reckless type of marketing that incites this criminal activity. Mm-hmm. It's not going to be the shooter. It's not. I mean, it's going to be the victims. So what the court has said, which we identified earlier, was these are the people who are going to be first in line. There had been a case brought about 10 to 15 years ago by the city of Bridgeport, by Ganem, the mayor of Bridgeport at the time, and he was trying to recover for costs associated with the gun violence in Bridgeport under CUTPA. And they said, well, you're really one step too removed. You're not like the victims of gun violence. Okay. So we had that kind of going for us as well. Yes. It's even more complicated than that, but it was a hurdle.
Well, let's take a step back. So you've won this decision, and this decision, what does it actually mean? What happens from here in this case?
Right. Well, this shouldn't be confused with us winning the case. Right. Okay. This is simply the Supreme Court saying you can continue with your case into the discovery phase. Now, the discovery phase is an area where, I think of it like as a castle with a moat and a dungeon, and there's a dungeon of documents. And the defendants never want you to get into that dungeon, and they'll do anything they can to avoid you getting into that dungeon. What the Supreme Court essentially or figuratively done is given us now the key that we needed to get there. So that's next for us.
And that trove of documents can lead in a lot of different directions, right? I mean, in the example of tobacco that I used before, it was discovery that was conducted over many, many years that showed that the tobacco industry was well aware of the impact that cigarettes were having on people. What do you think, or I know you don't know, but as you go into this discovery process, what are you hopeful to find?
Well, I'd like to, first of all, this is both similar and different than tobacco. With tobacco, it was all about what they hid. And one of the things that's astonishing about the marketing that we see with the gun industry is that it's right there in our faces. So what would normally be a smoking gun is actually right there. When you see these ads, they don't just drop out of the sky. That advocating for the combat value of this weapon, photographs of the imagery of the lone gunman, copy like forces of opposition, bow down, you have been single-handedly outnumbered. Those aren't accidentally put out there. Those are well thought out things. So we know there's a marketing plan. We also know that Remington was very pleased with the success of their plan, and they published in their financial statements the long-term outlook was very rosy in terms of the younger demographic. So we know their plan was working in their minds. To get there, you have to have a lot of documentation, work, focus groups, things like that. So we're hoping to see just how targeted this plan was. And also, I'm curious to see whether anybody at Remington raised any objections, because none of us are saying that the actual people at Remington are bad people. They ended up with this marketing and plan that was clearly immoral. But how did they get there? And did anybody say, hey, wait a second, maybe in the age of lockdowns for schools, maybe in the age of mass shootings, maybe we shouldn't be pushing this lone gunman, this machismo, this violence, because don't you think we might be increasing the risk to the public? I just want to know.
At the end of the day, for someone who feels strongly about stronger gun laws, about taking weapons like the AR-15 off the market, how far, even if you're ultimately successful in the case, how far does that really get those people toward that goal? Because if marketing of the guns is essentially the issue that you're working on, and the gun manufacturers just say, okay, well, we'll just change the marketing.
Right.
Is that essentially as far as you can really get with this claim, is that they'll have to change the way they market the guns, but at the end of the day, they're still going to be legal as long as Congress or states don't act to make them illegal?
Yeah, well, first of all, there's the lawsuit can only accomplish so much, because we're not a legislative body. And just getting back to we did lose part of the case where, I mean, in the broadest sense, I had felt after learning about the weapon and after seeing the law, I thought, well, doesn't there come a point at which it is simply negligent to entrust this weapon at all to any civilian? Mm-hmm, right. What more evidence do we need right now than what is provided on at least a monthly basis with somebody using this weapon, a civilian using this weapon against other civilians? That's not what the weapon is for. Is it really worth it? And hasn't this experiment failed colossally? How many more? I don't want to get up on a soapbox, but really, how many more bodies have to pile up before the evidence sinks in that these weapons don't belong in civilian hands? Having said that part, to the extent that part was ever in the case, it is out.
Right. The court felt that there wasn't enough evidence that the manufacturer could have possibly foreseen, right, what was going to happen. The gun was sold to the mother, of course, not to the perpetrator of the crime. So you had that additional step and hurdle that had to be proven, that not only did they need to know that they needed to know somehow that this this person was in the house, that he was likely to commit a crime.
Exactly.
And that's
it was a bridge too far legally.
Yeah.
I think it at this point, though, I think we did I disagree with that part of the court's ruling very emphatically. I think that we put on, at least we made a claim that if we could prove, ought to have been enough to say that, look, in this day and age with all the evidence right in front of everybody's eyes, that they clearly should have foreseen that this weapon could end up in the hands of somebody that would use it in a school shooting. Because not only could it happen, it has happened. Mm-hmm. So that there will be a time, there'll be a day of reckoning. And it'll be a shame because a lot more people will have lost their lives, a lot more communities will have been uprooted, a lot more families will be in the position of the Sandy Hook families that don't have to be. But this epidemic, this AR-15, this is just a failure of leadership, like you see right even recently in New Zealand, the real leadership. But that is not going to be part of our case. To your point, I think that the case that any responsibility that is or accountability against the gun company here will have the effect of getting them a little bit more engaged in potentially the solution instead of exacerbating the problem. And I think everything takes time. In the legal system, things take time, and I think that the takeaway here is already that you are not above the law. And once you're not above the law, you got to start acting like a corporate citizen in this case. And you have to start looking out for things other than your bottom line, and maybe consider trying to make things a little bit less risky for the public.
Taking a step away from the legal side of this for a second, what have you heard from families since this ruling last week?
Well, I think that the biggest feeling is a sense of being listened to. These are families that have been at this for nearly 5 years legal in terms of our case, but almost 6.5 years since the event. And some have tried to make changes in the law. Some have had success. The reaction by Congress. So I think that just the feeling that the law doesn't work, just to step back, I think there's a perception by the public that the law favors the rich, the powerful, the politically connected, and sometimes the evil. And I think this is a reminder to the families and hopefully to the public that the law exists for all of us. It's really there for all of us. And it's time, and you can't lose hope, and you have to remember that so it's an optimistic feeling and a sense of some accomplishment for the families.
And finally, for you, you're a member of this law practice that's a third-generation law practice, if I'm not mistaken. Yep. What does it mean for you personally to be a part of something like this, to achieve a legal milestone that not many lawyers can say they have on an issue that is certainly at the forefront of importance for so many people right now?
Well, for me, it just is a great restoration of my feelings about the law and its role in helping people, and to the extent that my grandfather had a lot of cases that made a difference. My father's had cases that made a difference. This is a case that I hope will make a difference. And it's just also not screwing it up for the families. At the end of the day, there's no better feeling than delivering for a client, and these are extremely worthy clients.
Congratulations.
Thank you, Rob.
Result. Best of luck.
Appreciate it.
The case. Thanks for joining us.
Thank you.
Appreciate it. You can watch more interviews like this on personainterview.com. You can follow us on Facebook, Instagram, Twitter. We'll see you next time.